history with its enforcement action order, asking for the suspension of processing activities until OpenAI was actually in a position to demonstrate compliance with the variety of requirements, and it was clearly driven by concerns for children, as you can see. And in particular, it was asking for age verification. We've got also other enforcement actions. I've got one here from the ICO against TikTok. TikTok was speaking just in the panel, in the previous panel. The enforcement process was maybe slowed down by the one-stop shop mechanism. But we shall see if we get other fines now that DPC has the fine. The ICO, actually, in that space, could be said to have led the movement with the adoption of the age-appropriate design code of practice. It came into force in 2020, although we've had a 12-month transition period for online services to conform to the code. What is it that we have? Where does the code come from? So it's actually coming from the UK Data Protection Act that is asking the ICO to produce a code of practice. So this is a statutory code of practice. And you can see that within the Data Protection Act, the intention is to have quite a broad code of practice and to make sure that we've got standards for information society services which are likely to be accessed by children. What are age-appropriate design? What does that mean? That means the design of services so that they are appropriate for use by and meet the development needs of children. And what are standards of age-appropriate design of relevant information services? Standards of age-appropriate design of such services as appear to the Commissioner to be desirable, having regards to the best interest of children. So that's a very important term and standard that will explain, at least on paper or in theory, the measures that have been listed within the code. Following up upon the ICO code, we've got now on the other side of the pond, and this is why we've got Eric with us today, the Californian equivalent has been clearly influenced by the ICO code, although obviously the legal system being different, we cannot draw similarities between the two in all cases. There will be implication in terms of enforcement that will be peculiar, obviously, to the Californian system. CNIL, so the French Supervisory Authority, has also drawn some guidelines on child rights online, and also more recently on age verification, and we'll speak about this also later on. The EU is also looking at the problem, and we know that we've got a special group who is going to work on, again, an age-appropriate design code, trying to make it a voluntary code. And we can see that there are links between here, clearly, data protection and content regulation. The intention is to produce something that could be bridges between the data protection, the Digital Services Act, and the Audiovisual Media Services Directive. And the DPP is also working on guidelines. It's very much in the state of a draft because the topic is not exactly consensual. I might have forgotten one or two supervisory authorities. I've added the work done by the Irish Supervisory Authority, who does not always enjoy taking the lead, but in this case, we've got sort of guidelines on the matter. No delay there. Underlying the discussion, we've got key questions, and in particular, questions relating to data protection by design and by default. But remember, if we look at what we have in GDPR, and if we look at the provisions actually expressly deal with children, we don't have a requirement to implement age verification, at least expressly within GDPR, and it's certainly not in Article 8. There is a requirement for promoting the adoption of code of conduct, but again, there is no requirement for implementing age verification there. So as I said, underlying the debate that we are going to have today, we've got two questions, at least, again, from an EU perspective. What does it mean to do data protection by design and by default for children? And is it all about data protection and data protection by design by default? Let me finish my introduction with another question, or my last question. Are we not looking at the tip of the iceberg only when we focus on age verification? Are we missing the big picture? And are we not, at the end of the day, putting the iceberg upside down? I will not answer my question. As I said, I'm not the expert in the room. I am fortunate enough to have a group of experts that will give you an overview of the situations in the EU and also a comparative perspective with Eric, who is sitting in California. So let's start our discussion. And I'm going to turn to Tony, who is actually the CEO of ACCS, which is a certification scheme that is coming from the UK, covering data protection and privacy for age assurance services. Tony, can you give us an overview of the UK landscape? Say a few words about the ICO Code of Practice and your own scheme.
Thank you, and good afternoon, everybody, and well done for sticking out the last session. So hopefully we'll get through it all. Yeah, my name's Tony Allen. I am sort of day job is chief executive of the age check certification scheme. Our role is that we test that identity and age check systems work. So we're not a builder of age verification systems. We're not a developer in that sense. We test that they work. So people come to us to be able to submit them for testing, be that biometric testing or ID verification testing or whatever. As a part of that, we run two certification schemes that are approved by the ICO in the UK under Article 42 of GDPR, and they were in fact the first schemes to be approved anywhere under GDPR, Article 42. One deals with the relationship with the requirements of data protection and privacy for age assurance and ID assurance service providers. So those are the people who are doing the ID checking and doing the age verification or age estimation or age inference testing. And the other one deals with the technical requirements for the age-appropriate design code, which Sophie has already laid out in terms of what the ICO produced under Section 123 of the Data Protection Act. And those are available for companies to be able to apply for certification. And that certification is specifically referenced in things like Article 25, so where you're looking at putting into place appropriate technical and organisational measures for data protection by default, demonstrating that you've used something that is certified under either of those two schemes is specifically referenced in that article as evidence of conformity. So it is useful in that sense. We are also working with the Luxembourg Supervisory Authority on extending it back to the European Union after the UK took its bat and ball home. So we are going to go through that process with them hopefully, and with EDPB to get it across the whole of the European Union as well. Just sort of moving on to what your question, Sophie, which is about where this is in the UK. You are quite right in that the UK has really led the world in thinking on this. Not entirely smoothly all the time, but it's definitely been a pathfinder. Back in 2017, the UK Parliament passed a piece of legislation called the Digital Economy Act. And part 3 of that act was intended to start to introduce requirements for providers of adult entertainment services online, such as pornography, to implement age verification. I think it can only be described as a fairly disastrous implementation of that piece of legislation, which has led to the government sort of withdrawing it and now coming forward with a new piece of legislation, which is in part 5 of the online safety bill, which is currently going through Parliament again. And that led to a range of actions in the UK in relation to the protection of children from online harm, exposure to things that could cause them harm, and also really embryonic at the time, but now quite burgeoning age assurance industry, largely based in the UK and a lot of UK providers. There are providers elsewhere, but there's a lot of UK providers in amongst that. And that really has started to form the basis. And one of the lessons from the part 3 of the Digital Economy Act and the fairly disastrous approach to implementing it was, if you're going to do this, you have to do it in a privacy-preserving way, because the campaigners against Part 3 were all like, this is about global tracking and Big Brother watching you and all those sorts of things. So what's emerged to support that has to be in that privacy-preserving manner. So standards, compliance, all the technical requirements about how you do age assurance in a way that is ensuring that you get the correct answer, but that you do it in a privacy-preserving way. And a part of that relates to another job that I do, which is I am the technical editor of the international standard called ISO 27566 on age assurance systems. It's currently going through its drafting stages. And that looks at how you build the framework for how these systems will operate, again, critically in a privacy-preserving way. So there's lots of lessons from the UK's implementation. It is pathfinding, so I don't want to be unkind to them, because they started with a very blank sheet of paper with not a lot of parameters on it. They have learnt by trial and error in some cases, and they have been also caught up with by, for instance, California with the age-appropriate design code there, the work on the fundamentals in Ireland, but it's still pretty cutting-edge stuff. So I'll pause there and hand back to you.
Okay, thank you for drawing out the big picture here, at least from a UK perspective. Can I ask you quite a blunt question? How easy is it to implement age verification and age estimation solutions that meets that protection by design requirement?
It's pretty easy these days. Certainly, if I went back a couple of years, it wouldn't be that easy, but certainly now it is pretty easy. There are lots of different methods available, but it has to be risk-based. You have to consider what your risk is and the level that you want to get to, the level of assurance that you need. Because you could be doing something within a game, for instance. You could be doing something where you just simply want to be able to spot whether somebody is likely to be the right age group, so that they're being presented with an age-appropriate experience. Or importantly, remember, age verification works in reverse, making sure that they're not in an area that they shouldn't be in, so that adults aren't within spaces that are designed for children. And you could do that in a very privacy-preserving way by the size of your hand when you're playing the game, doing the pinch gesture. Without revealing any data about that person, you are simply saying a child has got a smaller hand than an adult has. Through to the collection of things like a passport or a driving license, which is quite privacy intrusive. But the way that these systems are set up and certified is about only extracting from that data and then returning a yes or no. This person is over 18, aged 18 to 21 or whatever. And that data not being then used for other purposes or leaking into other things. So that's a really important thing about using third-party age verification services as opposed to first-party stuff. So it can be done. There are lots and lots of options now about how you do it. and there are certification out there and testing out there. Which, if you had asked me the same question 3 years ago, I would have said not very easy at all.
And how could you? I mean, how do you? If you had to give a few rules of thumbs here, how? If there is a great variety of solutions, how should someone pick and choose, and what would be the main drivers for the decision?
So start with the problem you're trying to solve. So start with what it is that is on your website or in your service that requires you to go through some kind of age verification. Think about the flip of that as well. Think about whether or not you're trying to prevent people who aren't that age from accessing the space or the services. Then look at the modalities of how your users interact with you, and you will find that there are various low friction or easy ways in which you can resolve that from the various providers that are out there. The next thing I would say is shop around. There are plenty of choices out there. I would say there are probably now the best part of 40 age verification service providers. And ask them some tough questions. Ask them questions about their accuracy. Ask them questions about their what's called outcome error parity across different genders or skin tones or biases within algorithms and stuff like that. Ask them about their how global they are, whether they can just service a particular country or whether they have facilities all over the world. And when you come to implement it, don't necessarily think that I've got an age verification provider box ticked. One of the things that we're starting to see more and more of now is what's called vendor concentration risk. If you, as part of your website, put a age verification tool on there and you've got one single provider, that is one single point of failure for your website. If that provider disappears or is unable to services or has got downtime, your customers won't be able to access your website. So providing choice and providing a spread of vendor risk will help you to ensure that your website and your service is resilient. Okay.
Well, thank you. So you've said that 3 years ago we had not very much. Today we've got plenty of solutions. What are the remaining open challenges in the space then, if any?
I think there are still challenges. The more data you collect, the more challenging it is and the more friction there is there. I think the biggest challenge is then how you move from website to website. So interoperability across your system. So if you are surfing and you are going from place to place, having age verification pop-ups will become even more annoying than consent pop-ups. On different websites that you visit. So how you achieve that through interoperability between the different service providers. I think there is lots more to be done on device development. So how you might have something within the tokens and the encryption within, for instance, a phone. That's still an area of development. And actually the standards, although the services are starting to be there, the standards are catching up, so there's still probably a year or two away before we do have an international standard for age assurance systems. I'm working hard on it, but there's a little way to go yet. Okay, well, thank you. I'm going to turn to Eric now, who is a law professor at Santa Clara University School of Law in the US. Welcome, Eric. I wanted you to give us an account of US law, and in particular, the recent initiative in California, the Age Appropriate Design Code Act that we now have over there. Could you draw the big picture for us?
Yeah, thank you. Thank you for including the conversation. This is my first time at this conference, and I'm delighted to be here, though it would be better in person as opposed to 6,000 miles away. You mentioned in your earlier remarks how many efforts there are to protect children online, and that really has become a dominant theme among regulation in the United States. Basically, every bill that's targeting the internet says for the children as the main point of political validation or justification for the effort. So we are in the midst of a nationwide and really a global effort to figure out what does it mean to protect children online? What are the tools that we need to impose regulatorily in order to achieve that? And what are some of the potential downsides? California last year enacted the age-appropriate design code, which kind of bypassed all of that and really didn't go through the kind of vetting and diligence that you would expect for a broad-based sweeping regulation of online content and interactions. And it really is because of this framing of it was all justified by being for the children that allowed the bill to skate with really little opposition. Basically, the proponents were able to say either you're for the children or against them, which one? And that allowed a bill to get through that really isn't ready for prime time. And we discussed it already that there's an incoherent market for age verification. The bill in California requires almost every online business to do age verification of their users. And so Tony was mentioning about risk-based assessments or whatever. Most businesses don't want children on their site. They're not intending to make money off of children. And yet they will only be able to comply with the law by engaging in age verification in the first instance to determine who is a child, and then most likely to tell them to leave, to go away. The Age Appropriate Design Code has some other things that will be familiar to European audiences. It requires basically an impact assessment about the consequences of new products or features. That impact assessment will be available to the regulators basically on their demand, which creates a lot of tension for development of new products and services. And finally, then there's a package of obligations once a user is identified as a child that are under US law cannot be complied with. Basically say you must put the best interests of children up front, which I think means something different than it does in Europe, because that basically creates a fiduciary duty to children, which no website can really honor, especially if they don't have an ongoing relationship with them. And the last thing I'll mention is that there's a lot of privilege in the assumption that a business can know what's, quote, in the best interest of children. And one of the things that we've learned, I think, is that children are not equally situated when it comes to interacting online. Some children are sometimes harmed by content online. That same exact content might be helpful for other children. So if we establish this monolith called children, we actually create a zero-sum game where some communities might be in opposition to each other, but the businesses have to pick only one. That's a challenge they cannot navigate.
Okay, thank you. So a rather critical view of the new act. US law already, at least at the federal level, had a previous act to solve parts of the problem, COPA. Could you say a few words about that specific piece of federal law and say whether this is still fit for purpose or whether we needed to add something else?
So, the Children's Online Privacy Protection Act, or what we sometimes refer to as COPPA. This was actually part of a wave of for the children regulation in the late 1990s. And so this was actually an extension of the last big time that we had this regulatory push to try to protect children online. COPPA is built on an old style of privacy regulation. It uses the fair information practices, notice, choice, access, and security as its animating principles. Some people might still believe that there's some value to those. I think most people in the privacy community believe that those are not robust enough to protect individuals. The law divided the world between people who are 13 and older and under 13 children, which is an odd division nowadays. Of course, most of the efforts today are trying to divide between 18 and under 18s. So it was a different solution, basically saying that teens are more capable of taking care of themselves than under preteens. And the law punted on the most important question, which was, how does a website know that it's dealing with someone who's under 13? And the law said that either the site is directed towards children under 13. That's their raison d'etre. That's they should know that if they're going to have a say a stream of those kinds of users, or they have to have actual knowledge that they're dealing with children under 13, which is a pretty rare standard, not going to be met in most circumstances. So by punting on that, what it did is it allowed a lot of plausible deniability by websites that have many child users. They aren't targeting those under 13s, and they don't know which particular users are under 13, and therefore they don't even have to comply with COPPA at all. I think that the modern view in the United States is that COPPA was a product of its time. Today, what we need is a comprehensive federal legislation that covers all users, whether they're minors or adults.
Okay, and going back to the Age-Appropriate Design Code Act, so you said it borrows from the UK ICO code of practice, but it's not a code of practice. Is this the main problem, that borrowing coming from the UK implemented into California law without understanding that there is a big difference between a code of practice and the statute?
Critical. It really is a problem for the conversation, because those who favor the UK solution think that it is extensible to another context like the United States or California. And it really isn't. There's a bunch of assumptions built into the legal framework in the UK that don't apply in the US. And I'm just going to mention two. The first is that in the US, we generally require laws to be very specific about what businesses can or cannot do. Without that kind of clarity, then they're not given fair notice about their obligations. Now, in the UK, and I would say more generally in Europe, there's a greater acceptance of the idea that there will be a dialogue between regulators and businesses that will work towards good outcomes in good faith, that will accept the fact that there wasn't rigorous, bright line tests for whether or not the business complied with law or not. That doesn't work in the US. We don't tolerate that kind of ambiguity. It's actually a violation of our legal standards. The other main problem is that the United States has the First Amendment, and the way that the Age-Appropriate Design Code applies, it requires validation of a user's age before they're allowed to read content. And that validation of age before reading content, it violates the First Amendment. We had several court battles about this 20 to 25 years ago, and uniformly the court said you cannot require age validation before people are allowed to read content. So that wasn't the real goal of the Age-Appropriate Design Code, but by translating it into a new context, it created this enormous legal friction that ultimately, I hope will substantially limit, if not eliminate, the law altogether.
Okay. And so from a US perspective and a Californian perspective, how should we then tackle the challenge of privacy and child online safety?
So this is an existential question for our society. What do we need to do to help children flourish in the digital age? And the Age-Appropriate Design Code, I'm sorry to keep beating up on it, but you can tell it's really not the right solution for us. Basically sets up incentives to kick children offline altogether and simply say, you're persona non gratis to us, we will not deal with you. And to me, that cannot be the right result, that we need to teach children how to be good digital consumers, how to be able to protect their interests online and offline. And anything that says we're going to keep you safe by foreclosing your access to digital resources that are going to be part of your future, a critical part of your future, and you'll get the tools or the keys to that kingdom when you turn 18, but we'll never have trained you how to use them. To me, that just seems so regressive and really harmful to the ultimate children's interest. But overall, the biggest question, and it really goes back to this phrase, what's in the best interest of children? That is an empirical question that can be answered through studying and by understanding the needs of children. And that's not what the regulators are doing. They're not doing evidence-based decision-making. There was a report released just a couple weeks ago by the American Psychological Association, the most respected group for psychology here in the United States, that said, we need to help children use the internet but they need to use it. That's part of their growth and development. And there's many communities for whom that's essential to their psychological well-being. So at the moment, we're having the regulators trying to push more children offline when the psychologists are telling them we need to help them understand how to use online better, but we cannot take it away from them. And that regulatory tension is why I fear for the future of the internet, because what's in the best interest of children is an empirical question, but the regulators aren't asking it that way.
Thank you so much, Eric, for giving us the overview of US law and giving us insights into how we should be approaching the question of the best interests of the children. Now I'm going to leave the US and go to France, where Martin sits. He's a member of the Innovation Lab at CNIL, the French Supervisory Authority. And so I'm going to ask him to give us the position of the CNIL on age verification and age estimation.
Thank you. Hi, everyone. I will just have to explain a bit our position by giving some French context, which is not very far from the UK context, actually. In 2020, a new law was voted in by the French Parliament that basically made illegal the age verification by self-declaration. So basically, you can no longer implement the simple button, I'm over 18 or I'm of age, to go to pornographic websites. So several months after that, in June 2021, the CNIL gave an opinion on the decree that was related to that law and on this specific point. And here's what we said in it. There are 4 main points. The first one is obviously you don't want to have a direct link between your identity documentation and the website, the pornographic website. That's pretty obvious, I guess. You don't want to have a link between your identity, your legal identity, and your browsing on such content. The second point is you shouldn't use the browsing history of the user as a means for an estimation of the age of the user. That doesn't seem proportionate because, well, with browsing history, you have a lot of information about the user, so that doesn't seem to fit. The third point is on the same spirit, I would say, no use of, processing of biometric data. So Article 9 of the GDPR, that means that you don't want to have biometric identification in order to have access to pornographic websites. And the fourth point was we strongly recommended that, like Tony said, an independent and trusted third party should be involved in the process, and in order to prevent data transmission that shouldn't happen. So as you may have understood by now, this is a complex topic that raises a lot of concerns and issues regarding privacy. So after that opinion, in 2021, we decided, the CNIL, to carry on our work on that specific topic. And so we decided to make an analysis of the whole ecosystem. That means the actors and the solutions that were proposed to websites in order to do the age check. And in July 2022, we published a long communication that Sophie showed you just before. And I wanted to share with you a few key points of this communication. The first one is to understand how age verification works. You have to understand that it's 2 different operations. The first one is the issuance of a proof of age. So that means somewhere someone knows you and can attest that you are over 18 or you are of age over the threshold that is requested. The second point, is that the second operation is transmission of that proof from the verifier that attests your age to the website that you want to visit. The second point we wanted to stress in that communication is that there is no perfect solutions. We won't be here actually if there was. What we meant by that is basically it's because of how the internet works. It's an open network. You can freely have access to it as a user, as a publisher, but also because there is existing tools that allows user to bypass or to circumvent this system of age verification, like VPN. That's not a call to ban VPN at all. That's not a position of the CNIL. I want to stress that very strongly. But I give you some example of what was our analysis of some of the solutions that are proposed on the market actually. First, there's a credit card. If we go through pros and cons, it's easy to use. It's already an existing and secure infrastructure, so that's pretty good to use it. But on the other hand, minors in France can have it, so that's not that perfect solution. And the problematic that we saw when we analyzed it is that it will increase, maybe strongly, the risk of scam and phishing. So we are far from a perfect solution. If we go through age estimation through facial analysis, it's the same. It's easy to use as well. You can do it. Could be done on the device of the user, so that's a pretty good thing. But on the other hand, there is still statistical error, and that are with algorithms. There is still this kind of issue. Tony mentioned it just before, and there is this question of intrusiveness. Because you have to open your camera in order to have access to the website you want. And if I go back to pornographic website, it's not fit very well as well. I can go on. There is also offline verification. You can purchase a card with an ID and a password that allows you to go online. It was tested in the UK, and then I think it was abandoned. Because of social pressure as well, because when you are in the supermarket and you are buying such a card, you are saying that you will have access to restricted adult content afterwards. So I can go on, but I will stop here. But the main message here, and Tony will agree with me, because of these imperfections, because of how the internet works, if this solution were to be deployed, they have to be certified, they have to be audited on a regular basis, and you have to implement, to involve a third party that is a trusted one and an independent one. And we talk a lot about issuance of the proof. I want to take just a couple of minutes to talk about the transmission of the proof. And at the CNIL, we wanted to prove that it's possible to create an ecosystem that protects the user privacy. And so we teamed up with a professor of cryptography, which is with Olivier Blasi, professor at École Polytechnique. And we made a proof of concept. We wanted to demonstrate that it can be done in a good way. And how it works, it relies on two cryptographic principles. The first one is digital signatures. The other one is zero knowledge proof. And it works like this. The website you want to access ask you for a proof of age. You get that request, you transfer it to a verifier. That means a service that knows you and can attest that you are over the age. It will sign cryptographically that request, send it back to you, and you will give it to the website. What's interesting in that proof of concept is that the website will only get two information. The first information is that you are of age, you are over the threshold. The second information is that this information comes from a verified source and a trusted source. What's interesting as well is that the website doesn't know who you are. It doesn't know who is the verifier. The verifier doesn't know where the request comes from. It doesn't know what you're going to have access with that proof afterwards. So basically, that's something I would say virtuous. The last point I wanted to stress about this proof of concept, we wanted it should work, and at the user end is at the center of this scheme. Everything goes through him, so he's on control on everything that on the proof of age. And obviously, we are respecting data minimization principle because there is very few information that are shared between the actors. That's why it was called double anonymity. So it's not anonymous GDPR principle, but cryptographically it is. And that's it for me.
Okay, thank you. So at least from your perspective, there is a solution which is not in practice yet, which is only a POC, a proof of concept.
Yes.
Have you met any interested party coming from the private sector looking at your POC?
What was the most interesting is that the French government heard us and asks for experimentation that should involve double anonymity. So there is, and the government launched experimentation with this objective. So there are industrials that are testing it, and we will have some results at the end of the year. But the CNIL is not involved in to follow the experimentation. So we don't have all the details. So I can't say more than that. I'm sorry.
Okay, that's fine. But very briefly, so we don't have the POC is not a reality yet. If you had to give two pieces of advice to a broad audience about how to think about age verification and age estimation, if someone was thinking to try to implement a solution of this type,
yes,
what would you say?
Yeah, first, the POC is a theory and not a practical one, but it's not that innovative actually. Digital signature are well known. It's used every day nowadays in a lot of digital work. And zero knowledge proof is something like 30 or 40 years old, so it's a well-known concept as well. What's more complicated, actually, it's not the technical part. It would be the governance. It will take time and will to construct, to build up something with a governance like that. But it's been a year now that we publish our POC, so I mean, we are waiting for something to happen,
Okay.
and we stay vigilant on it.
Okay. Well done. Well, thank you for the overview. Now we'll go back to the best interest of the child, and we'll have Eva give us an overview of child online safety and the different rules that we have on this side of the pond.
Okay, thank you, Sophie. So yes, when I think back to your slides, Sophie, I think the question that spoke to me the most was the one, is this only about data protection? And that's, I think, what I want to show, that it's, if we think about children in the digital environment, that it is definitely not only about data protection, and that we should not forget the big picture. So when I was starting my research a long time ago, when we were talking about children and digital technologies, basically everything was left here in the EU to self-regulation. And different coalitions were set up at the EU level. But slowly and then gradually we have seen this evolving into what I think I like to call a maze of different instruments that are all in some way relevant when we talk about children's safety, but also children's agency in this online environment. Of course, on the top of the slide, you see some of the instruments that we have currently that have been adopted. The General Data Protection Regulation was a prudent effort, I would say, because it did mention children. It says that the data, personal data of children merits specific protection. And in some ways, this has been integrated in some specific provision that Sophie also showed on some of the slides regarding Article 8, child consent. But at the same time, we also have the Audiovisual Media Services Directive, for instance, which has become applicable to video sharing platforms. We all know that children use video sharing platforms daily, hourly, in some cases. So there as well, the video sharing platforms need to take certain measures to make sure that programs, but also user-generated content, does not impair the development of children. And of course, and that's something that I will show on the next slide, these video sharing platforms, they are not only providers of these video sharing services, but they are also data controllers. So you see that if you look at the different pieces of the puzzle, that they are applicable to many of the same players. And that is, of course, also the fact when we look at the Digital Services Act. I think in the children's rights community, this is an instrument that we have been following from its inception. And if we compare the references to children in the proposal of the Commission, there were some, but very few. And if we look now at the finished and the adopted text of the Digital Services Act, there is quite some potential. So providers of online platforms need to take appropriate and proportionate measures to ensure a high level of privacy, safety, and security of minors. This is one of the most clear, most specific provisions that we have to date, although it is still quite abstract. What are these appropriate measures? In addition to those instruments that might be applicable, there are some proposals on the table, some of which we have been talking about extensively over the past few days. In the proposal for an AI Act, there are some references to children. Some of the prohibited systems refer to children, but also when we look at the obligations on providers of high-risk systems, so they need to take into consideration whether a certain AI system might have an impact on children. We also extensively talked about the CSAM regulation. There was a very interesting panel this afternoon, very critical panel. And I think I can wholly concur that this is a very controversial proposal that really also shows how the interests of children conflict. Of course, there's an interest to protect children against child sexual abuse and the dissemination of material, but at the same time, there are other interests, such as the interest regarding privacy and data protection must also be taken into account. Another proposal is the one on combating violence against women and domestic violence. It's not one that is often talked about in this field, but it actually could be quite important because it does address deepfakes and also the non-consensual dissemination of intimate images, which we know from research many children also struggle with. And then the final pieces of the puzzle are instruments that are not legally binding, but that provide some insight into how the EU looks at these issues, so the Better Internet for Kids Plus strategy, for instance, which has also announced in the context of the DSA that an age-appropriate design code will be adopted. Sophie also mentioned this expert group that will be set up, and which might potentially provide us with some more guidance on how these appropriate and proportionate measures could be envisaged. And then something that we also often do not talk about, and especially not in a data protection context, is consumer protection. But this is really a field that has also a lot of promise and potential to address some of the concerns that we see when it comes to children in this digital environment. Also, for instance, regarding recommender systems or loot boxes in video games. So this is the maze. And I just wanted to give you one illustration of the situation that this leads to. The letters are very small, but basically it's an illustration of how video sharing platforms can fall within the scope of many of these instruments, both the AVMSD, also the GDPR, the Digital Services Act, the proposal for an AI Act. On the right side of the slide, you can see what the obligations, or at least some of the obligations are that are imposed on these actors, on video sharing platforms such as YouTube, TikTok, platforms that are really used very extensively by children. And you also see a reference to the regulators that are competent, or that will be competent in the future to enforce this. So you have all these different instruments, all these different obligations that are sometimes a little bit similar, but also have some differences. And then you have all these regulators, both at the national and at the European level. So this really creates quite a difficult and a complex situation, not only for those who need to comply, but also for children and their parents who are often not aware of what these obligations are that the companies that their children come into contact with need to comply with. And then a second very interesting observation is that you see that all these documents start addressing the same types of things, but in a slightly different way. So when we look at the General Data Protection Regulation, one of the big questions when it came out was profiling of children. The GDPR does not explicitly prohibit profiling of children, but it says that profiling of children deserves special consideration. In the aftermath of the adoption, the Article 29 Working Party mentioned that it would expect organizations to refrain from profiling children for commercial purposes or for marketing purposes. So this was an interpretation of the GDPR. If we look at the AVMSD, then we see that because the AVMSD requires the video sharing platforms to put in place measures such as age verification, which we have been talking about extensively, there is suddenly a provision in this document on audiovisual media that says that if the platforms acquire personal data in the context of these processes, that they cannot use it for commercial profiling. And who will enforce this? Will it be the DPA? Will it be the national media regulator? These are all questions that pop up. And then, of course, in the DSA, we see that now there is a prohibition for online platforms to target advertisements based on profiling when they're reasonably certain that the recipient is a minor. So you see this kind of bizarre evolution and the reference to different, in these different instruments, to the same type of phenomenon. But again, it raises quite some questions regarding enforcement and who will be competent to make sure that the different actors comply with all of these requirements. So I think this is a little bit the bigger picture. It's not only about data protection. We need to take into account the full range of children's rights when we talk about these issues. And perhaps most importantly, we also need to take into account their views and listen to children when we make these decisions about regulation, and this is very often not done yet.
Thank you, Eva. One quick question before I give the audience the possibility to ask more questions. How do we define the best interest of the child? I mean, we've heard distinctions between a protective approach and a holistic approach. Can you say just a few words about that distinction, maybe?
It's a very difficult question, and it's like kind of this magic word that everyone tries to use to when we talk about these issues, the best interest of the child. I think most importantly, it's crucial to have attention for all rights and not only look at one perspective. Age verification can be really useful to protect children from certain content, but at the same time, it restricts their freedom of expression, their right to receive information. So whenever we think about what we actually want to achieve, taking into account all these perspectives and the conflicting interests is really important. And with that, one of the most crucial guiding factors is also the evolving capacities. So a child of 9, a child of 14, and a child of 16, they are not the same child.
So there is not one fits all approach. Thank you so much, my panelists. Now I'm going to give the audience the possibility to ask questions. Please, go ahead.
Hi, hello, Martin Sass from the Catholic University of Leuven. I have a question regarding, you mentioned the fact of verifying age based on the double anonymization, right? With this ecosystem with the issuer and then the service provider. Currently, there is the revision of the EU IDS 2 directive, regulation, sorry, which have this objective of having this European digital wallet, which attributes that you could, that the user could decide to reveal to certain providers. It's a bit difficult for me to see like what is currently out there as in terms of solutions, because we also often mention different type of solutions. We heard about digital signature, we heard about zero knowledge proof, also self-sovereign identities, decentralized identities. Like, I don't know, I would like to have your perspective on how those works currently and whether it's mature enough, whether there are still the challenges. Of course, it's a very big question, but just to have like just a few perspective on that and how would it be actually ready for potentially be implemented and used widely. And then I have a small additional question, but it's more for you, Tony. I know that you was before involved in the EU consent project, which had the aim of having this interoperable platform for all Europe and providing those attributes easily. What are the outcome of this project? Is it still running? Is there still some work which is done in this direction? Thank you.
Can we? Is there another question?
Yeah.
Can you just ask your question now? Quickly, please, because we.
Yeah, sure. Hi all. Actually, I'm a DPO, one of the company, and we produce the app develop stuff. And our app allows the parents use the geo-tracking of their child. So my question to all of you, firstly, how we can ensure the balance of the best interest of child if he or she directly contact us and say, come on guys, can you stop this practice? Since literally we have to contact their parents and ask what are we going to do here, because obviously, yeah. So my question, if there is a conflict between interests, yes, I mean parents and child, what we have to do. And the last question to Martin: what's your perspective? What are you going to do, for example, if this child bring the complaint against us and say, "Come on, guys, they abuse their practice"? So yeah, that's all.
Thank you. And the last question, very quickly.
Very quickly, you talked a lot about the rights of children. What about the rights of adults? That's been the primary issue in litigation in the United States, that if adults have to prove that they're not children, that has been held in the United States to violate their right to anonymous expression.
Thank you. Martin, do you want to start?
Yes. Okay. About eIDAS, digital wallet, and a lot of things is going on, and it's difficult even for us to have to project and to anticipate what's going on. But you can tell that it's not at the same time. We need something now. eIDAS is still in work, and we don't know when it's going to be validated and comes into force. So we need to act in the meantime. And like you said, eIDAS talked about digital wallet, attestation, attribute, and everything that is directly linked with our proof of concept. So that means perhaps in the future it will work with a digital wallet, a secure one. So yes, probably it will merge, it will converge somewhere, somehow, but we don't know how. And like Tony said, even for a certification, an international one, it's like in 1 year or two, and we have to progress on that. On you consent, you know best.
I'll be quick because I know we're running short of time. Just two things to say, really. First is don't fall into the trap of thinking that age assurance is necessarily about identity. Your age is an attribute of your identity, but it isn't necessarily the case. You have to identify somebody to be able to tell how old they are. You can look at me and you can see that I'm over 18. You don't need to know who I am, my name, my ID, or anything to be able to do that. You can do that just by looking at me. So think about age assurance from the point of view of, first of all, how you might allow somebody who you know or somebody knows to be able to access something, but also how you might be able to allow somebody who is a stranger or completely anonymous, going to the point about the US, to be able to access information as well. And my second thing on EU consent. EU consent was a project that was funded as part of a pilot program by the European Commission. It did complete and was relatively successful. There is currently work on what they now call a preparatory project. I'm not sure what the difference between a pilot project and a preparatory project is, but that is ongoing, and we are in discussions with the Commission about that. It has now been set up as a Belgian NGO here in Brussels as EU consent, EBSL, I think. And that will be taking that project forward. The website is still there, all the material is still there, all the information is still there. We are just currently working with the Commission on how it is progressed into the next phase of the project, which is frankly taking the pilot and I think running it across the whole of the Union.
Thank you. Eric, do you want to say a few words about the rights of adults, or?
Sure. Just to reinforce the comment, here in the United States, we recognize that any restrictions on speech that are targeting children have implications for adults. And so setting up barriers for adults to access content is very squarely restricted by the First Amendment. And there is subsumed within that an anonymity protection that adults should get the right to access that content without having to reveal themselves. And with respect to Tony, doing a face scan is probably not consistent with any expectations about anonymity, even if the vendor promises to flush the scanned face as part of its work. So yeah, so here in the United States, we're having a very different conversation. The only question that I see relevant is whether or not the laws have been implicitly changed because of the change of the Supreme Court or because social norms have changed. Otherwise, we dealt with all of this 25 years ago, and almost everything that we were discussing today doesn't fly under U.S. constitutional law.
Okay, thank you. Very clear. Eva, do you want to add something?
Yes, I think also from the EU perspective, the rights of adults are very important. Just as there can be conflicts between the rights of children, there can be conflicts between the rights of children and the rights of adults, even the rights of the companies, their freedom to conduct business. So it's really a balancing exercise of all these types of rights. The only thing, when we are talking about the best interests of the child, and the United Nations Committee on the Rights of the Child has mentioned in some of their documents that whenever this balancing exercise is done, a larger weight should be given to what serves the child's interests in the best way. But it definitely does not mean that the rights of adults should not be taken into account. But probably not in the same way as is the case in the US.
Thank you so much. This is the time. This is the end of the panel. You've got the conclusion of the conference up in the main room. Thank you so much for being with us until the end, and have a very nice weekend.
Thank you.